This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a who's on first issue and not an Abbott and Costello routine, where defense and or indemnity become an issue between more than one insurer, and they needed to take it to the U.S. District Court and the United States Court of Appeal for the Fifth Circuit to get a resolution, where there is an insurer versus insurer dispute, it should have been resolved by agreement or by mediation rather than litigation. In an insurance coverage dispute that arose out of the tragic death of an employee of a construction site, the Fifth Circuit was called upon to determine which insurer was obligated to deal with the claims of the family of the deceased employee, because the insurers could not agree. In Gemini Insurance versus Indemnity Insurance Company of North America, a January 12, 2024 decision of the United States Court of Appeal for the Fifth Circuit, the court dealt with the coverage disputes over which insurer is obligated to defend and or indemnify which person or entity. ExxonMobil Corporation retained Bechtel Oil, Gas and Chemicals as a general contractor to build a new hydrocarbon processing facility in Beaumont, Texas. As part of its contract with Bechtel, ExxonMobil implemented an owner-controlled insurance program, an OCIP, which provided workers' compensation and employers' liability coverage to Bechtel and all of its subcontractors. Bechtel retained Echo Maintenance, LLC, as a subcontractor to perform mechanical, structural, and piping work on the project. Bechtel and Echo subsequently entered into a contract that incorporated the OCIP and required Echo to enroll in the program. Both Bechtel and Echo were enrolled in the OCIP. Under the terms of the OCIP, Indemnity Insurance Company of North America, Indemnity, issued a workers' compensation and employers' liability insurance policy to Bechtel. Separately, Gemini Insurance Company issued a general commercial liability policy to Echo, under which Bechtel was an additional insured. Part 2 of the OCIP policy sets forth the types of covered claim that Indemnity agreed to defend and indemnify Bechtel. The OCIP contained what was called a VCEL endorsement, whose first provision explained that the endorsement adds voluntary compensation insurance to the policy and that the insurance applies to bodily injury by accident so long as it is sustained by an employee included in the group of employees described in the schedule and arises out of and in the course of employment necessary or incidental to work in the state listed on the schedule. The employer's liability insurance defines state of employment in relevant part as Texas, but only at the site indicated in the designated premises endorsement. In December of 2017, Mrs. Espinoza was working as a pipe fitter helper on the project when she was struck by a piece of pipe and sustained fatal injuries. In response to the suit brought by her heirs, Bechtel sought coverage as an additional insured on the commercial general liability policy issued by Gemini to Echo and received a defense from Gemini under a reservation of rights. Bechtel then moved for summary judgment on the heirs' suit because ExxonMobil's OCIP provided blanket workers' compensation insurance and coverage to Bechtel and Echo. The intervener's sole remedy, in accordance with Texas Labor Code, was workers' compensation benefits, and therefore the state granted Bechtel's motion for summary judgment on the suit brought by the heirs. The main issue before the Fifth Circuit was whether Mrs. Espinosa was an employee of Bechtel within the terms of the OCIP policy. Reading the VCEL endorsement together with Part 2, the Fifth Circuit concluded that the only reasonable interpretation was that the VCL endorsement expanded the definition of a Bechtel employee. The ordinary meaning of employee is someone who works in the service of another person under an express or implied contract of hire, under which the employer has the right to control the details of work performance. The Fifth Circuit concluded that the VCL endorsement expanded the OCIP policy's definition of employee to include employees of Bechtel's subcontractors such as Ms. Espinosa. Mrs. Espinosa was an employee of ECHO, but also simultaneously working for Bechtel at the designated premises, thus satisfying the VCEL endorsement, making her an employee also of Bechtel. Ms. Espinosa was killed while working in the scope of her employment. The allegations, therefore, of her heirs' lawsuit, construed liberally, constitute a claim potentially within the OCIP policy, and as a result, Indemnity had a duty to defend Bechtel in the underlying litigation. There was no dispute that Ms. Espinosa was an ECHO employee, that ECHO was a subcontractor of Bechtel, that Bechtel and ECHO had a written contract, and the work they performed was on a designated premises within the meaning of the OCIP policy. The workers' compensation OCIP coverage applied. Bechtel provided workers' compensation insurance to ECHO when they executed the subcontract agreement, and Indemnity, therefore, had a duty to indemnify Bechtel as well, because the district court concluded that Indemnity did not have a duty to defend or indemnify Gemini. It never addressed the substance of Gemini's subrogation arguments, and therefore the Fifth Circuit reversed the district court's grant of Indemnity's motion for summary judgment and remanded the case back to the district court with instructions to grant Gemini's motion for summary judgment on Indemnity's duty to defend and indemnify under the policy, and to consider the subrogation issues in the first instance. In my opinion, insurance policies must be dealt with as an entirety, and no matter how extensive or complex. Once the court determined that Mrs. Espinosa was an employee, it resolved the dispute and found that Indemnity owed defense and indemnity to the defendants. The insurers should not have engaged in this litigation, but worked out a resolution to the benefit of the insureds with the assistance of a mediator, if necessary, who is knowledgeable about insurance issues. Failing to do so, after the expenditure of a discovery, a summary judgment, and an appeal, the obvious resulted a case where only one party was happy, and there existed a possibility that much could have been saved by an agreement between equals, the two insurers. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And you will also gain access to the more than 4,700 blog postings. You can also subscribe to the videos at YouTube and at rumble.com, both of which are free. And with your subscription, you will have access to the videos, and if you watch them as you are watching this one, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. I'd also appreciate it if you follow me on X, the old Twitter, at bzalma, where you can also see these videos and blog postings. And if you're interested in more detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.